Hi guys, good evening and welcome back to Gradeup. My name is Harshmeet Singh and you're watching me live on the Gradeup IAS YouTube channel. This is the beginning of a new mini series. As promised, this week from Monday to Friday, I will be bringing you a set of mini series, that is a set of 5 videos. In these 5 videos, in 5 videos, we will be covering the higher judiciary of India. So we will be covering everything regarding the higher judiciary, everything related to the Supreme Court and the High Court, which will make sure that you cover this entire topic within 5 lectures. Nothing outside of it would be important for higher judiciary. Higher judiciary के लिए Supreme Court और High Court के लिए, if you attend these 5 lectures, that would be good enough and that would complete your topic of higher judiciary. So don't forget to catch me live Monday to Friday, 7:30 p.m. live on the Gradeup IAS YouTube channel. Now, today is the beginning of that mini series, and I welcome everyone, those who have joined in. Good evening to all of you guys. Don't forget to hit the like button. Don't forget to hit the subscribe button also. Now, to begin this mini series, today we have the Supreme Court. Now, I will be discussing about the Supreme Court in two classes, one today and the other one tomorrow. Today we will be starting with appointment and removal of judges in the Supreme Court. The powers and functions and the jurisdiction of the Supreme Court will be covered in tomorrow's live class. So I'm sure many of you would have heard or read about Supreme Court quite a bit. But let's start from the most important part, that is the appointment of the judges. Now, right now, at present, there are a total of 34 judges in the Supreme Court of India. That includes the Chief Justice of India also, meaning that there is a Chief Justice of India and 33 other judges in the Supreme Court right now. If you have books which are slightly older, they might tell you that there are 31 judges, which is wrong. So do correct that part. In 2019, the Parliament amended the Supreme Court Number of Judges Act and increased the number of judges from 31 to 34. Now, remember, guys, this is the first biggest takeaway. If you have to change the number of judges in the Supreme Court, if you have to increase the total strength, or you have to make any change in the total strength of the Supreme Court, it is the Parliament that has the power to do that. It might get confusing because in case of High Court, the President has the power to do that. But in case of Supreme Court, it is the Parliament that has the power to do that. The Supreme Court started with total of 8 judges only, and from time to time, with the increase in population, increase in number of cases, the number of judges have been increased in the Supreme. In fact, the 34 judges that we have today, many experts said even these are too little. We need at least 50 judges, 50. And the reason is, in the Supreme Court alone, there are 60,000 cases pending, 60. There are 60,000 cases pending just in the Supreme Court. But I will talk about the reason behind pending cases in one of the lectures in the mini series only. I think lecture number 4 on Friday. So do join in there also. So Parliament of India can regulate or can decide how many judges will there be in the Supreme. As you know, the Supreme Court of India sits in Delhi, which is the principal seat of the Supreme Court, the headquarter or head office, whatever you want to call it. However, the Constitution of India says that if the Chief Justice of India wants, or if the Chief Justice of India thinks that there is a requirement, then the Chief Justice of India can make sure that a new seat of Supreme Court is set up. So a new seat can be set up apart from Delhi. However, this has not been done so far because this is just an optional thing. If the Chief Justice of India wants, he can go ahead with it. Now, why is it that the new seat should be set up? Or what would happen with the new seat? See, we have just one Supreme Court and that is in Delhi. But we have to realize that India as a country is a huge country. We sometimes underestimate the size of our area. Yes, we have a huge population that everyone knows, but in terms of area also, India is a huge country. So let's say someone not living in Delhi, someone living in Tamil Nadu, someone living in Nagaland, someone even living in Gujarat, for them to come and file a case in the Supreme Court in Delhi. Now the case will go on for many days. You can't just have a case for one single day. So the case will go on for so many days. So for so many days, staying in Delhi, making arrangements in Delhi is not feasible. This is why we have seen that mostly when the cases come in the Supreme Court, they are mostly from the northern states only: Delhi, UP, Haryana, Himachal, Punjab, Madhya Pradesh, maybe. These are the states which usually have cases in the Supreme Court. But state like Kerala, Tamil Nadu, Karnataka, they don't really have any case in the Supreme Court because for them, it's not easy to come all the way there and take their cases. So that also is a suggestion that Chief Justice of India should open a new seat of Supreme Court, but he has not done so till now. Now, who exactly can be a Supreme Court judge? What are the qualifications to become a judge of the Supreme Court? First, obviously, the person should be a citizen of India. Apart from being a citizen of India, there are three requirements out of these three. So, one out of three requirements have to be fulfilled. These are the three requirements. Any one out of these three have to be fulfilled. Either the person should be a judge of the High Court for 5 years, or the person should be an advocate of the High Court for 10 years, or the person should be a distinguished jurist in the opinion of the president. Now, who is a jurist? Jurists usually are experts of law. Now, expert of law can be, let's say, a law professor, those who have written books of law, a person who has done PhD in law, those kind of things, a researcher, that is a person who will be called a jurist. You have to fulfill one of these three qualifications. Now, in the history of India, so far, from this third criteria, it is a jurist criteria, no one has been appointed as a Supreme Court judge. In the Supreme Court, no jurist has been appointed as a judge. Usually, in usual circumstances, when you have judges being appointed in the court, they are usually appointed from the first criteria only. The first criteria, that is, they should be High Court judges for 5 years. Even appointing a High Court advocate as a Supreme Court judge is a very rare occurrence. It also does not happen. It happens very, very, very rarely. ऐसा नहीं कभी हुआ नहीं है. It has happened, but it's a very rare occurrence. But jurist being appointed as a Supreme Court judge has never happened in the history of India. The Constitution does not even give any minimum limit for the Supreme Court judge in India. There is a retirement age that is 65, but there is no minimum age limit. Now, coming to the most significant part of it, that is the appointment of the judges. The Constitution says that the judges of the Supreme Court are appointed by the President. Now, this first line is not controversial at all. Everyone accepts and understands the meaning. It is, however, this line that is the center of a debate. The line is, the Chief Justice of India is appointed by the President after consultation with such judges of Supreme Court and High Court as he deems necessary, while the other judges are also appointed by President after consultation with Chief Justice of India and other judges. Now, the entire problem about this is on the word consultation. Let's take it one by one. Let's first talk about appointment of Chief Justice of India. So usually what happens when the Chief Justice of India retires, like he retired recently, the next senior most judge of the Supreme Court will be made the Chief Justice of India. Like S.A. Bobde, when his tenure got over, it was N.V. Ramanna who became the next Chief Justice of India. So the Chief Justice of India, after the person retires, the next senior most judge will become the Chief Justice. This is what usually happens. The formality is that the outgoing Chief Justice will give a name to the President. This is usually the name of the senior most judge only. Remember, when I say senior most, I don't say senior most by age. What I mean is senior most by experience. So whoever is the most experienced judge in the Supreme Court now, senior most by experience and not by age. So this is how the Chief Justice of India is appointed. However, there have been two instances in the past when this was not followed. When Indira Gandhi was a prime minister, this was not followed a couple of times. However, apart from these two couple of times, usually whatever is whoever is the next senior most judge of the Supreme Court, that person is appointed as a chief justice. So there is not a lot of controversy about that. The controversy, however, or the debate is about the other judges of the Supreme Court. How are they appointed? For that controversy or for that debate to be decided, it is important to understand the meaning of the word consultation. What does the word consultation mean? The President of India will appoint the other judges after consultation with the Chief Justice of India. Now, let's say there is a vacancy in the Supreme Court. Okay. And the President of India asked the Chief Justice of India, कि भाई there is a vacancy, who should I appoint? Let's imagine that the Chief Justice of India told the President, कि sir, there is Mr. X, very respected judge from Allahabad High Court, let's appoint him. And this is a consultation, right? Now the question is, can the President say no to this name? Or is the President bound by it? This is the question. What exactly is the meaning of the word consultation? Is it binding or is it not binding? Binding means concurrence. Is the word consultation the same as concurrence? Concurrence means binding. President ko manna hi padega. President has to say yes to that name only. On the other hand, is it not binding? What can the President do? This is the debate around it. Now, if you look from the President's point of view, let's try to look from the President. So, President has to appoint someone. He is asking the Chief Justice of India, who should I appoint? And the Chief Justice of India, let's say, gives a name. If it is binding on the President, then obviously Chief Justice of India or the judiciary has the power to decide who will be the next judge. On the other hand, let's assume it is not binding on the President. Okay? Let's assume it is not binding on the President. If it is not binding on the President, that means that the President will listen to whom? The Council of Ministers, right? The President anyways does not do anything on his own. President has to listen by default to the Council of Ministers only. So if the President is not bound by the name given by the Chief Justice of India, then he will ask the Council of Ministers, "Bhai, tum bata do, you tell me who to appoint." Meaning that it is a struggle between the judiciary and the government about who will decide the next Supreme Court judge. सुप्रीम कोर्ट का नेक्स्ट जज कौन बनेगा, ये डिसाइड करने की पावर किसके पास है? दिस इज व्हाट द एंटायर डिबेट इज अबाउट. Does the judiciary has the power to decide who shall be the next Supreme Court judge, or is it the government that has the power to decide who shall be the next Supreme Court judge? And all that is dependent on the meaning of the word consultation. If the word consultation is binding on the President, then the Chief Justice of India will decide. If the word consultation is not binding on the President, then the Council of Ministers will decide who will be the next judge. Simple, right? Now, when such a controversy comes up that you have to interpret something that is written in the Constitution, who interprets it? The responsibility of interpreting the Constitution, what is the meaning of some words in the Constitution, is with the Supreme Court only. So it is the Supreme Court only that had to decide what exactly is the meaning of the word consultation, so that the judge's appointment can go on properly. So what did the Supreme Court do? Supreme Court decided the meaning in 3 different cases. And these 3 cases together are called the 3 judges cases. The first judges case happened in 1982. In this case, the Supreme Court said that the word consultation is not binding. So in 1982, in the first judges case, the Supreme Court said that the word consultation is not binding. When you say consultation is not binding, you mean to say that the judges, whatever the Chief Justice of India says, is not binding. So the word consultation does not mean conference or binding. It only means exchange of views. This is what happened in the first judge's case. Okay. Now, meaning that after first judge's case, the Chief Justice of India used to give a name to the president, but the president was free to ignore that, and the president would listen to the government. Government was obviously very happy. The judiciary was not that happy anyway. Second judge's case came up in 1993. Now, Supreme Court has a very peculiar power, and that power is to go back on its own judgments. So, if the Supreme Court has earlier given a judgment, it can remove its own or alter its own judgment. In the second judge's case of 1993, the Supreme Court reversed the judgment and said that from now onwards, abhi ke saath, consultation will be binding. From now onwards, consultation is binding. So now, whatever word is given, whatever advice is given by the Chief Justice of India, that advice has to be accepted. This was the second judge's case. In the second judge's case, Supreme Court also said that when the Chief Justice of India gives a name to the president, he will not give the name alone. He will himself talk to two other senior most Supreme Court judges, and then these three together will give a name to the president. The Chief Justice of India से consult करने का मतलब is not कि वो अपने मन से बता देंगे. He will consult two other senior most Supreme Court judges after him, and these three will then give a name to the president. And the president will then have to abide by that. This is the second judge's case. Then came the third judge's case of 1998. Now the interesting part is third judge's case was not really a case, it was a presidential reference. We have read about the president under Article 143. The president can ask a legal question or a question about law to the Supreme Court, right? So this is what had happened in 1998. The President of India had asked a question to the Supreme Court about the judge's appointment. He wanted some clarity about if the two judges have some other name in the mind, if Chief Justice of India has a different name in the mind, then what should happen? These kind of. So the third judge's case in 1998 was a case in which Supreme Court again repeated, right, the meaning of the word consultation will be binding. However, Supreme Court now expanded the number of judges who will give the recommendation. Now the Supreme Court said Chief Justice of India will consult four senior most judges of the Supreme Court and not two. And together they will give a name to the president, and that will be final. These judges are called collegium. The word collegium that you would have heard in the news time and time again, these are the collegium. Collegium means a group of judges that advise the president about the next judicial appointment in Supreme Court or the High Court. Now the interesting part is in the entire constitution, there is no mention of the word collegium. Collegium ka likha hi nahi hai. The word collegium is just an invention of the Supreme Court. The word collegium is invented by the Supreme Court that has given themselves the power to decide who will be the next Supreme Court judge. See how smart the court is. They have themselves given the power कि हम ही decide करेंगे कि कौन अगला आने वाला है, आप नहीं करो. So the collegium system started from there on. The Supreme Court also gave the process for how the name would be given. The process is that when the meeting would be held, the Chief Justice of India will bring a name, वो नाम लेकर के आएंगे, and then these four people will discuss it. Whatever name is suggested by the Chief Justice of India, at least three of these judges have to support it. At least three. Out of four, at least three have to support. If three judges don't support it, then Chief Justice of India should not send the name to the president. If three judges don't support it, at least three judges, then the Chief Justice of India should not send the name to the President of India. If he does still send the name to the President of India, then the recommendation should not be binding. It would only be binding if the Chief Justice of India's recommendation is accepted by at least three judges. That is when it should be binding, otherwise it will not be binding. So this is what the three judges cases are. This is what led to the beginning of the collegium system. And as I said, the collegium system, interestingly, is not mentioned in the constitution. It's not mentioned in any parliamentary law. It is just an invention of the Supreme Court. They themselves have invented something like this to give themselves the power to decide who will be the next Supreme Court judge. This process of appointment or this method of appointment is followed even today. Even today, judges of Supreme Court and the High Court are appointed in this manner only, meaning that the government of India has no role to play in appointment of judges in the Supreme Court and the High Court. The government cannot decide that this will be the next judge. And that is obviously something that the government does not like. There have been many commissions and committees in the past that have spoken against the collegium system. And there are many reasons for it. As I said, it is not mentioned in the original constitution or in any of the amendments. So it has no basis to be started to begin with. It is one of the prime examples of judicial activism where judiciary has itself taken up the powers. The second problem with this is it's a closed door meeting. When the collegium has a meeting and they decide who will be the next judge, no one knows how or how do they decide, because there are so many people who have been in high court as judges for 5 years. Out of them, who do they pick? What are the criteria they should apply? There is no questioning that is allowed. So there is not much transparency that is involved in the entire process, and that is why also it is suggested that there should be something new and not the collegium. What is that new? The government of India tried to change the collegium system by introducing a new system called NJAC. NJAC stood for National Judicial Appointment Commission. It was supposed to be a 6-member body, 3 from the judiciary, that is Chief Justice of India, and 2 Supreme Court judges, then a law minister and 2 other eminent personalities. In other words, NJAC would have 6 members, 3 from the judiciary and 3 from the side of the government. The point was that these people will tell the president who will be the next judge. So anyone's name to go forward would need at least 4 votes. Judiciary has 3 votes, government has 3 votes. So alone they cannot send any name. At least 4 votes will be needed. This was the idea of NJAC. The constitution was amended, the law was passed. But even before the law was passed, there was many people thought judiciary will not allow it to happen. Because why would judiciary also, Supreme Court also, any government organization, any authority wants to keep as much powers in their hand as possible. So if the Supreme Court has the power to decide who will be the next Supreme Court judge, why would they want to give up their powers? See, it's all about concentration of powers in the hands. So everyone thought that Supreme Court will not allow the NJAC, and that is exactly what happened. As soon as the NJAC was passed, and by the way, NJAC was a constitutional amendment. It was a 99th Constitutional Amendment Act in 2014. As soon as it was passed, the Supreme Court struck down the NJAC, calling it unconstitutional, against the independence of judiciary, against the basic structure and whatnot. And this was expected, that the Supreme Court will not just keep on sitting while the government takes away its powers. Supreme Court said that the government should not have any role to play in appointment of the judiciary, because in the Supreme Court, most of the cases have government as one party. So government should not be able to influence the Supreme Court, and that is true. So we are back to the collegium system of the appointment of judges even today. So the collegium sends the name. The interesting part is president does not have any fixed time limit to reply. That is a pretty interesting part. So collegium sends a name, government cannot change that name. But the government can delay it, because the president of India is not bound that within 6 months, within 6 weeks, you have to appoint the person as a judge. There have been many times when the judge's appointment have been delayed just because the government did not like a judge. So government also has this loophole. They also know that we can't change the name of the judge, but we can certainly delay the name, right? because there is no fixed time limit that within this time limit the person has to be appointed as the judge. So it's again a cat and a mouse game between the government and the judiciary about who shall control the judiciary, about who shall be in control or who shall decide the next Supreme Court judge. Now, the removal of the judge. The Supreme Court judge, and so far in the history of India, no Supreme Court or High Court judge has been removed. The Constitution, however, gives two reasons or two grounds for removal. They can either be removed for proved misbehavior, or incapacity. Misbehavior, for example, let's say giving biased judgments, or incapacity, they are not able to provide proper judgments. These are the only two reasons for removal of the Supreme Court judge. The removal process can start either in the Lok Sabha or in the Rajya Sabha. If you have to start in the Lok Sabha, at least 100 members have to support it to start. In Rajya Sabha, at least 50 members have to support. After 100 members supported, then the Lok Sabha Speaker or the Rajya Sabha presiding officer, they will decide whether the process should start or not. It is not binding on them, remember. So even if 100 members in the Lok Sabha say, yes, we want to remove the Supreme Court judge, even after that, the Lok Sabha Speaker will decide, okay, to start the proceeding or not to start the proceeding. If he wants to start the proceedings, then a 3-member committee will be set up, or 3-member commission will be set up. These 3 members will be Chief Justice of India, High Court Chief Justice, and a jurist. If the proceedings are against Chief Justice of India only, then there would be some other Supreme Court judge. These 3 or this panel will investigate the charges if the charges are true or not on these 2 grounds. If they think the charges are true, then the voting will start. The bill has to be passed by a special majority. There is a special majority that is required. Special majority of 2/3 members present and voting, and 50% of total. 2/3 members present and voting, and 50% of total. This is the special majority that is required. Once it is passed, it will go to the other house, whatever the other house is, Lok Sabha or the Rajya Sabha. In the other house also, the same majority will be required to pass this bill. If it is passed in both the houses, it goes to President of India, President signs on it, and that is how the judge is removed. So far in the history of India, no judge has been removed. Remember this. No judge has been removed so far in the history of India. No, when I say no judge, I mean no Supreme Court or High Court judge has been removed in the history of India so far. Yes, judges have resigned, but they have not been removed. This is about part 1 of this mini series. I really hope that you enjoyed it. As I said, in these 5 videos, we will be covering the entire higher judiciary. इसके अलावा आपको कहीं नहीं देखना पड़ेगा. Don't forget to like, comment, and share. And also, if you have not subscribed to this YouTube channel, please do that right now. Also, if you are preparing for the IAS examination, you can join the 2022 or 2023 foundation courses at Gradeup. You can also renew your EPFO subscription because EPFO exam is just around the corner. So make sure that you subscribe to this IAS course, over 500 live interactive classes, mock tests, PDF notes, and lot more. You can take the IAS 2021 prelims plus mains course, the IAS 2022 prelims plus mains course, the IAS 2023 course, or you can just renew your EPFO subscription. So that is all the option that you have. Gradeup Super offers you daily study plan, exam-centric focus, expert faculties, and the best of study material. So get structured study plans, expert faculties, best materials, and a lot of new faculties have been added for different subjects, making sure that no subject is unfulfilled. I teach polity, governance, and international relations, and there are many expert faculties who have come in from various fields. Like Ashish Kushwaha sir has just joined. He has over 8 years experience in general science and science and tech. We also have many other people: Nirmesh sir, Javed sir, Anand sir, Chetan sir, Aniket sir, Nikhil sir. All of these are people who are there to guide you with whatever requirement that you would have. We also have Mukesh sir, Praveen sir, who is a Hindi expert, Ajay Mishra sir, Rajiv sir, Deepthi ma'am, and many more. We're also on Telegram. Search for this name, Gradeup IAS Preparation Channel. Join this to get free study material and short notes. Thank you so much for joining, guys. Do join me tomorrow also for part 2 of this mini series. Till then, bye, guys. Take care.